It's a massive decision. Like we're talking close to 100 pages. It gets into a lot of preceding case law. It's actually quite technical. Yeah. The court found that some charter rights were breached, some were not, but all were saved. Does this close the book on this madness and this insanity? No way.
Adam Soos here for Rebel News, and I am very happy to be joined by Chad Williamson of Williamson Law. We have some pressing updates that extend, at least in part, from the Ingram ruling, if not entirely from the Ingram ruling. But just really quickly, we've been hearing about the Ingram ruling for a long time. Lots of the legal proceedings out there have been sort of pending on the Ingram ruling. But for folks who are maybe unfamiliar with out there, we don't want to just jump ahead. And so if you could give people a little bit of a context about what the Ingram ruling actually is.
So when there was a whole bunch of challenges coming from far afield, from Calgary, from Edmonton, to a lot of the COVID mandates during the pandemic, in order that there weren't some cases jumping ahead of others and conflicting decisions from one court that might affect other courts, the court tried to kind of triage or case manage a lot of these. And what they eventually decided is that they would pick one of the first cases to have come down the chute to be the precedential setting landmark cases. And at least in the case of Chris Scott, some of his stuff was put in abeyance by court order pending the outcome of Ingram. Now, this didn't just happen, a couple months ago. The Ingram case is actually a fairly robust constitutional challenge from a whole bunch of different churches, and a gal by the name of Rebecca Ingram who owned a gym, and a couple other litigants whose constitutional rights were alleged to have been infringed as a result of the smattering of COVID mandates. So we finally got the Ingram decision, and Adam, we've been waiting for this for almost 2 years. And for anyone that's been following this story, they've probably heard myself or other Alberta lawyers who are involved in this COVID litigation talk about the Ingram decision. Mm-hmm. Well, it's out and it's interesting. So maybe we can talk about that today.
Yeah, well, so I wanted to ask you now, obviously the ruling is in a sense a win because it was deemed that effectively most of the restrictions that folks were charged under have been struck down. Those Dina Hinshaw inspired CMOH, Chief Medical Officer of Health laws, they've been struck down. They're no longer in effect, and effectively people were being charged under them, under invalid laws. But there are some questions out there, and it really only is a partial win because lots of people didn't get their day in court. And there's also the consideration of the factor that the nature of the win was not these laws were unconstitutional and therefore have been struck down. It was Jason Kenney and the Alberta government basically overstepped. And that was the grounds. So can you just comment on that for folks?
That's right. So just to put it in very simple terms, it's a massive decision. Like we're talking close to 100 pages. It gets into a lot of preceding case law. It's actually quite technical. The court essentially found that all of the CMOH orders were ultra vires, which just means it's beyond the power that was granted through the legislation. And what that ends up meaning is that basically the court found that it was the cabinet and not the chief medical officer who was the main decision maker implementing these CMOH orders, and that runs contrary to the powers that are that flow from the Public Health Act and other legislation. Right. Now, kind of as a subrogated portion of that were a whole bunch of charter breaches, and this is, of course, what people are most concerned about, right? What's kind of interesting is because the court found that everything was invalidated as a result of the decisions coming from cabinet unlawfully as opposed to actually coming from the office of the chief medical officer, it invalidated basically almost all of the CMOH orders. Now, retroactively, we got to go back 2 years. People have been charged. Some people paid fines. Some people, like Chris Scott, were imprisoned. They were, we still take the position that he suffered a political prosecution. Right. And frankly, that may or may not be adequately addressed. Right. However, the court still said, in anticipating an appeal, said, if I am wrong on this ultra vires bit that basically invalidates these CMOH orders, I'm going to give a decision on the constitutionality of this.
Right.
Now, again, it would take us a while to go through that decision.
Right.
The applicants and the plaintiffs, Ingram and, of course, her fellow applicants, they threw everything at the wall. They pled every charter infringement.
Right.
I mean, that was available to them, and not wrongly. I mean, frankly, I still think that there were a whole bunch of charter breaches.
Yeah.
I don't necessarily agree with the court on their finding.
Yeah.
The court found that some charter rights were breached, some were not, but all were saved by Section 1, which, if you don't know, is the notwithstanding clause, which just means that there's a real connection between the purpose of, why the breach occurred.
Right.
And that even notwithstanding that there were charter breaches, these were just in a democracy.
Right.
So there were charter breaches, but you know what? It is what it is. Section 1.
Yeah,
Section
it's
1.
fine, apparently. And that's the grounds for lots of people's concern, right?
And this is a big problem. Whether or not this is a concern, I suppose we'll see if there's another pandemic or if there's more government overreach or further mandates. I mean, I'm hearing whisperings of mask mandates coming into place in schools in the States. So we're going to see what happens. But essentially, the court said, hey, look, there were some breaches. There weren't some breaches. Those breaches are cool via Section 1. In order for the government to lawfully implement future CMOH orders, those orders have to come from the chief medical officer. And of course, this causes a whole bunch of other issues.
Yeah.
Are they elected? Well, no. So do we want the orders to be coming from, cabinet or a committee, which might not be elected, or do we want them to come from some appointed doctor?
Right.
These are obviously discussions that we need to have as a province and as a society. I mean, at the end of the day, it's kind of a Pyrrhic victory. You know what I mean? I mean, yeah, it's the CMOH orders are invalid. A whole bunch of people, are going to end up having their charges either withdrawn or they're going to have acquittals entered. But what about the hundreds of people that either, were convicted prior, had paid fines voluntarily, donations to the food bank, et cetera, et cetera. And what about all the people that lost their restaurants or lost their businesses? So this kind of gets down to now the civil ramifications. Well, do these people have a civil remedy against the government? And that's obviously something that's being contemplated by dozens of lawyers across the province, including our office. And, there's going to be some time there to consider that. But it's not a great decision. Now, some of the folks, and this is very interesting. So Chris Scott, he's got a court appearance on Monday.
Yeah.
Well, he's been fighting this thing in court for roughly 2 years.
Yeah.
And yeah, he might get an acquittal, but we were just in the process of getting into some really, really greasy disclosure applications, and we believe that we had uncovered some political motivation by AHS through some of the disclosure. And of course, we're in the middle of a disclosure application. Well. Yeah. If he gets acquitted on Monday, as is expected, pursuant to the whisperings around the province, that disclosure application just goes up in smoke, and it prevents us from getting really to the meat of this stuff. So is it a victory? Well, of course it is. The CMOH orders are invalid as we thought they were all along, maybe not necessarily for the same reasons. So people can kind of take that, for people should evaluate this for themselves to determine whether or not they think this is truly a victory. Yeah. And the only recourse that we've got is legislative change at this point. Yeah. The appeal period, I mean, I know that this the Ingram decision, which is important, it came out at the end of July. You've got 30 days to appeal, and then it's toast. I don't have any knowledge that this thing is being appealed. So this Ingram decision may, in fact, be the law of the land after this.
Well, and so there's a couple concerns there. Obviously, folks not having their day in court, all the dirty laundry not being aired with all these acquittals.
We aired a little bit of dirty laundry.
A little bit. But there's also, and you touched on this earlier, and I think this is what folks might be very concerned about, there's the potential that in a couple months, let's say this new variant everyone is talking about, prompts CMOH, Chief Medical Officer of Health, to implement bylaws and they make sure not to talk, or laws, new restrictions, whatever they may be, and they don't talk to the government, then these same violations can be still deemed notwithstanding, and it was fine. Everything that happened was fine according to the courts. Is that right?
To a degree. Yeah. The most important thing is that at the end of the day, every case turns on its facts. Again, I like to use Chris Scott, his case specifically, as an example because it was one of the hardest fought constitutional and charter challenges, and a challenge just on the merits. Yeah. We had the investigating RCMP officer pass away halfway through the case without giving us the opportunity to bring him in and question him on the charter and constitutional portion. Now, we haven't even done the charter and constitutional portion. Now, Ingram was supposed to take care of that, but what might have applied to the applicants, the churches, Rebecca Ingram and the other litigants in that case, if the facts are different under, Chris Scott, who actually, he got put in jail. Yeah. We've got emails where Alberta Health Services seemingly joke about, don't tell anyone that this is politically motivated. Well, it's going to be up to the court to determine whether or not there is an inference there. And I know maybe it was a bad joke. But that's a pretty serious joke for an investigating agency to make in their official email. Right. And when people are joking, don't tell people that this is, and again, I'm paraphrasing as well. Yeah. So some of these materials are available online. There's a robust affidavit that contains some of these emails. A lot of this stuff is just going to go up in smoke. Yeah. So we don't even get to challenge the constitutionality and the charter infringements on Chris if this gets vaped on Monday as we expect.
Well, thanks for that clarification. I know people are concerned and wanted to get the facts down. Now, I do want to talk about the latest news. Media has been sort of running rampant, saying that all these things are being acquitted. They aren't done until they're done, and lots of these court dates are upcoming. But effectively, this stems from a report, and I believe the Western Standard broke this, so credit to them. But the Alberta Crown Prosecution Service, based on the Ingram versus Alberta decision, has determined that convictions are unlikely, and we've seen likely, or at least we expect as a consequence of that, Pastor James Coates, Pastor Tim Stevens, a bunch of other individuals, all their charges effectively evaporating. So if you could just comment a little bit on sort of, for folks out there who don't understand, like the charges just going away because there's not likely to be grounds for conviction.
Whenever you've got a criminal or regulatory proceeding, there's kind of two parts to that trial. One is going to be the trial on the facts, and this is just who done it and did they do it. Yeah. The next step is determining whether or not there were charter breaches that would give rise to a remedy to, perhaps have the case against them dismissed. And then, of course, if the charges are based on legislation that's unconstitutional, someone can challenge that. At the end of the day, what we're seeing, or at least we don't have all the information. Yeah. We've got a pretty good idea that we think that there is not enough to convict these people on. If the regulations, which is what the CMOH orders really are, and the regulations flow from the legislation, if those regulations were unlawful, can you convict somebody on invalid or laws that have been declared invalid? Yeah. In 99.9% of cases, the answer is no. Yeah. It's the duty of the Crown Prosecution Service. If they don't believe there is a likelihood of conviction, and in this case, I don't think that there is, quite frankly, if they proceeded, once we got to the charter and the constitutional portion, we would be waving Ingram like a flag, saying, "Hey, all this stuff is based on law that the Court of King's Bench has declared invalid." So we've got it on pretty good authority that, again, we've got 2 clients left in our Fight the Fines cases. Interesting, we've had 150. If we get Chris Scott, an acquittal for Chris Scott pursuant to Ingram on Monday, and then Wesley Langlois acquitted in September when we have a court date for him, that will mean that for all of the Fight the Fines that my office defended, over 150 of them, not one conviction at trial. Incredible. Think, Adam, of all the government resources that went into the Alberta Health Investigators, the correspondents, the RCMP, the Alberta Gaming and Liquor Board, who are yanking people's licenses. This massive monolith that was funneling money into going after these people. They didn't get one trial, conviction, at least for our clients.
Yeah. Perfect record from Williamson Law. That's something, certainly. I've got one final question for you, but for folks out there, interestingly enough, and this has been going on forever, my first story was, I think, when Chris Scott at the Whistle Stop was first served one of these notices. That's how long this has been going on for. People probably aware Chris Scott, the owner of the Whistle Stop, who refused to shutter his doors and basically became one of the faces of the ongoing COVID prosecution, set on Monday to likely receive an acquittal. But folks probably aware with that story, but maybe share a little bit about the Langlois and their story, as they're likely to be experiencing something similar in September, I believe. Is that right?
Yeah, so the Langlois story is a little bit different. The fellow's name is Wesley. He's one of the most charitable, gracious, humble, and kind of special people that I've met through this whole ordeal. And not to say that Chris Scott isn't a great guy or any of these other people aren't amazing. I've met so many amazing people. Wesley runs a diner. He essentially opened his doors for 2 days, not to make a big statement, not to shake the boat. He just wanted to practice his right to public protest and civil disobedience. Now, he was one of the very first cases that actually went down the pipe in terms of the trial, and he had a tremendously aggressive prosecutor on that case who spared us no quarter. We fought with her tooth and nail through this entire process. I chuckle a little bit that now all that effort was wasted when we've got, obviously real criminals who, need prosecution. No diss on her. She's obviously just doing her job, but what a waste, especially now that this has been vaped. Wesley owns Mom's Diner up in Red Deer. Again, humble guy. When I came into this, I've been running these cases, as most people know, with my, my compatriot, Yoav Niv, who is just a beauty of a guy, one of the best criminal defense lawyers, I think, in the province. Yoav and I have been running these hand in hand since day one, all 150s of these bad boys. And on this case specifically, we ran this first without having uncovered a lot of the, what we would say is maybe bizarre behavior from AHS. So we ran this as really just the defense case without knowing about the emails and the disclosure issues and having suspicions of political motivations, obviously, but not really have anything to sink our teeth into to kind of make a stink about that. And Wesley he's basically at the very end of the trial proper. And he was looking at a conviction, at least on the trial proper. Of course, the next step would be to move to the constitutional and the charter challenges. But we took that thing from stem to stern through the trial process without the disclosure stuff, without all the complicating issues. And he's really just looking at a conviction for just being a guy that, didn't want to go out of business. And that's really what it comes down to. He's not running a bunch of McDonald's or a Best Buy or a big box store. He's running a diner in Red Deer. And he helps people who have come from complicated histories, and he gives them positions in his shop to try to get them out of, maybe a different lifestyle. He's just a great guy. And the fact that the government brought the entire weight of this monolith down upon this guy with a prosecutor who spared him no quarter throughout, to have this thing potentially turn around in his favor, it makes us incredibly happy because Wesley doesn't have an axe to grind in this thing. He just wanted to protest, make a statement, and for that, the boot of the government came down upon him.
And that's why for folks out there who may be on the fence with the Ingram decision, you have to look at the human sort of outcomes and the fact that so many people who've been through so much are finally getting a breath of fresh air. Final question for you. Victories abound, but justice delayed is justice denied. And people have been in prison. We've seen dozens of people imprisoned. We've seen fines paid. Is there remuneration? Is there compensation? Are people going to receive their fines back? Is there going to be compensation, civil lawsuits? What's happening? Is there going to be justice?
That's a great question. And unfortunately, to the chagrin of my office and probably to the chagrin of viewers, we don't know the answer to that. That's kind of the next saga. Is there liability? I believe that there's a cause of action. Ultimately, will that result in remuneration or, reimbursement or some sort of a remedy? I have no idea. Frankly, despite so many of these resounding successes, I believe that, they might be rare. We haven't seen great or at least favorable decisions coming down from the court. Yeah, there's lots of wins. And another thing is that, a win's a win. If you go up on charges and you're looking down the barrel of a dangerous conviction that carries a hefty penalty and you're out, and those charges for whatever reason are unlawful, whether it's constitutional or whether it's just technical, if you're off, you're off. And in a roundabout way, justice is served. Does this close the book on this madness and this insanity? No way. Like, I think that this is, people are starting to wake up. Are people going to mask up again a second time? Are people going to, get 4 boosters? Are people going to, just roll over and close their restaurants again or close their gyms? I don't know. I think we're seeing stronger resistance to this type of overreach. So I don't know what's going to happen. Are there remedies? I hope so. Yeah. I hope so. We're thinking about it.
Well, there is certainly wonderful news coming out of the courts in Alberta, thanks to all the incredible legal work that is being done in a major part, thanks to all of your contributions at fightthefines.com. People across the country are still fighting. And one of the people who took a lead and took a key role of responsibility in pushing back against these mandates, against these restrictions, is Tamara Leach. And she spent time behind bars and is still fighting for her legal freedom. We are crowdfunding her legal defense at helptamara.com.